Judge, it has everything to do with the charge. It's charged with 2 counts of being felony child abuse.
All right, we have other motions, including a motion to suppress and a motion to sever, but today we're only going to deal with a motion for reduction of bond. So, is your motion, Mr. Simpson, you may call your question.
Yes, Judge. First, I just request the rule.
Rule if they're requested, so if there's anyone who is in this courtroom that is going to be a witness, you must go outside of the courtroom and remain outside the courtroom until you are called to testify. You're not to discuss the testimony of any other person until such time as you have testified yourself.
All right. First witness that I would call would be Candy Beard.
I'm making sure you guys
Are you Kennedy? You come up here, ma'am.
Just right around here, please, ma'am.
You solemnly swear or affirm that the testimony you have given in this case be the truth, the whole truth, and nothing but the truth and nothing but it.
I'm sorry, did you answer?
Yes, ma'am.
Around here.
Your name Candy Beard.
Yes, sir.
Could you please spell that for the court reporter?
Candy, Beard, Beard.
Thank you, Ms. Beard.
And you're gonna have to speak in directly into that microphone, please, ma'am.
A little bit up. There you go. Just make sure you're close to it, okay? All right. What is your relationship with Ethan Beard?
He is my son.
And so would it be fair to say you've known him his entire life?
Yes, sir.
How long has he lived here in Humphreys County?
All of his life.
Did he graduate high school here?
Yes, sir. In McEwen.
Does he have family here?
Yes, sir.
How much of his family resides here?
All of them.
Does he have friends here to your knowledge?
Yes, sir.
Are most of his friends here in Humphreys County?
Yes, sir.
To your knowledge, has he ever been charged with a crime other than this case?
No, sir.
Would you say that what would you say about his character for reliability? Is he a reliable person?
Yes, sir.
Would you vouch for his character for
Yes,
reliability? Have you ever known him to be untrustworthy?
Yes, sir.
Hey there, sorry to interrupt the video, but I wanted to take a moment to let you know that TCF is a channel that is 100% human created and human driven. There's so much AI slop out there on YouTube right now, especially in the LawTube space, that I think it's important to point out that every video that we have here on this channel is human created, human curated. We make all the decisions, we do all the editing, it's all us. So if you appreciate that human touch and that human interaction, please do consider subscribing to the channel if you aren't already. Leave us a comment on the video, put a thumbs up. Those things really help us. And if you want even more human interaction, consider joining us for our live show every weekday morning. Okay, sorry to interrupt. Back to the video.
That's all I have.
Todd, no question?
Yes, Justice Brewer. Ms. Beard,
Yes, ma'am.
did you say that you are Mr. Beard's mother?
Yes, ma'am.
Okay. So you testified that you believe him to be reliable and trustworthy?
Yes, ma'am.
Okay. And of course, he hasn't had any prior charges,
No, ma'am.
but he has had some charges, right? He's had a driving unsuspended charge.
Well, yes, ma'am.
It's not completely accurate to say he's had no charges.
Well, I didn't think about that, so sorry.
That's all right. Are you aware of the allegations against Mr. Beard in the cases that are now pending before the court?
Yes, ma'am.
Okay. So you understand that Mr. Beard is charged with two B felony counts of child abuse and neglect.
I just don't believe that.
Well, I didn't ask you that. I said,
Yes,
you understand
ma'am.
he's charged with
Yes,
that.
ma'am.
You understand he's charged with aggravated assault against his ex-girlfriend,
Yes, ma'am.
mother of his children,
Yes, ma'am.
as well as domestic assault against her.
Yes, ma'am.
You aware he's left bruises and marks on his ex-girlfriend? I'm asking if you're aware that that's the allegation that's been made.
Yes, ma'am.
Are you aware of the allegation that he's left bruises and marks on all 4 children that were in the home?
Yes, ma'am.
So you're aware of all those things, but you still feel he is a reliable, trustworthy individual.
I
Yes, ma'am.
object, Judge, to the relevance regarding the children. I don't think that that's charged in this case.
The state would just respond that obviously the other 2 children are not part of this case. It would not be admissible at trial, but it does go for purposes of whether or not he is any kind of danger to the community, things that would be relevant to a bond hearing specifically.
Bond hearings are a little different, so more factors are allowed to come in to allow the court to make an intelligent decision. So overrule the
Thank you.
objection.
Thank you, Judge. So where would Mr. Beard live if he were to get out of jail?
He would live at my house.
Who all lives at your house with you?
Just me.
Do you know if Mr. Beard has a job or the ability to get a job?
He don't have a job now, but hopefully after, if he gets out, then he will get one.
But he didn't have a job when he was arrested either, did he?
No, ma'am.
Does Mr. Beard, do you have other family in the community?
Yes, ma'am.
Who all, or what's the closest other relatives that he has?
His sister.
Sister?
Yes.
And moving on to another case of Mr. Beard's. Are you aware that he's been charged for theft and vandalism for stealing water from the city of Waverly?
Yes, but yet can I also say that Kate knew about that because.
That's not the question I asked you. I asked if you were aware that he was charged for theft.
Okay. Yes,
He's the
ma'am.
one trying to get a bond reduction here.
Okay, yes, ma'am.
Do you think theft charge is an indication of someone being reliable and trustworthy?
Yes, ma'am.
That doesn't bother you?
Is there an answer?
I don't think so. I think did you shake your head? I could not tell. If you could answer yes or no.
Yes.
And are you aware that after your son was charged with aggravated assault and domestic assault against Miss Miller, that he attempted to call her multiple times from the jail in direct violation of the bond conditions?
No, ma'am. I wasn't aware of that.
Well, he is charged with that. Would you have any reason to not believe me if I tell you he's charged with that?
No, I believe you.
No further questions, Judge.
You redirect.
Yes, Judge. As far as his character for reliability, would you say that stealing water from Waverly, would that be consistent or inconsistent with his character generally?
That's not Ethan, so it is inconsistent.
I'm sorry, I couldn't hear your answer.
Inconsistent. And that's not Ethan.
Okay. And as far as the allegations against him, are you aware, has he been convicted of those charges yet?
Not that I know of.
And as far as the allegations of domestic assault, had you ever personally observed Mr. Beard get into arguments with Caitlin Miller?
Yes.
Okay, and who was the primary aggressor during the times that you observed?
Whenever I observed and I got videos of it, it was Kate.
Okay, and was he trying to leave and she kept following around the house?
Yes. Yes, sir.
And would you say that attempting to choke Caitlin Miller unprovoked would that be consistent with his character or inconsistent?
That's not even so inconsistent.
Okay, so for all the time that you've known him, would you say that his character, what you know about him would make you shocked to learn that he actually did what he's accused of being charged with?
Yes.
Nothing further.
Any reading false, General?
No, Judge.
Thank you, ma'am. You may step down. You have a seat in the courtroom if you like. All right, next witness.
Brittany Frederick?
Brittany Frederick?
Yes, ma'am.
Brittany Frederick?
You solemnly swear or affirm that the testimony you now give in this case shall be the truth, the whole truth, and nothing but the truth, so help you God. I do. Absolutely.
Do me a favor and just speak directly into that microphone. Could you please state and spell your name?
It's Brittany Lachey Frederick, BRITTANYLESHIE
And do you know Mr. Ethan Beard?
I do.
And how do you know him?
We were together for 2 years.
And how long have you known him in total?
I would say probably about 7, 8 years.
I'm sorry, did you say 8 years?
7 or 8 years, yeah.
Just speak with your full chest if you don't mind. It would really help her out. Thank you. And you said that you were together for 2 years.
Mm-hmm.
Was that immediately before he began his relationship with Caitlin Miller?
Yes.
And do you feel like during all the time that you've known him, that you know him well enough to have a pretty accurate opinion as to his character?
Yes.
Do you feel like you have known him well and long enough to have an accurate opinion as to his character for being a violent or non-violent person?
Yes.
What is your opinion?
He's not violent. Ethan is a loving, caring person. He's a family man.
Do you feel like you've known him long and well enough to form a pretty accurate opinion as to his character for trustworthiness?
Yes.
What is that opinion?
He's definitely trustworthy.
Have you known him to be a reliable person?
Yes.
Does he do what he says he's going to do?
Yes.
Would you be willing to vouch for his reliability?
Yeah, absolutely.
Has he lived in Humphreys County his entire life?
Yes.
Do you know, does he have any family or friend connections outside of Humphreys County? Any meaningful connections?
Not that I know of.
Did you know Caitlin Miller at all?
I did not.
That's all I have.
General?
No questions, Judge.
Thank you. You may step down.
Thank you.
All right, next witness.
Yes, Judge. The next witness I would call is Erica Carter. Erica Carter? Yes.
So Brown here, please, ma'am, raise your right hand and be placed under oath.
You solemnly swear or affirm that the testimony you now give in this case shall be the truth, the whole truth, and nothing but the truth, so help you God. Yes.
See.
Could you please state and spell your name for the record?
Erica.
We have to move
If I
up.
could,
We don't have a very good sound system. You have to really directly speak into that microphone. Okay?
Erica Carter.
Just like this.
Erica Carter, ERICA. What's my last name? DARTER.
Thank you.
Mm-hmm.
What is your relationship with Ethan Beard?
His sister.
Would it be fair to say you've known him his whole life?
Yes, sir.
Do you feel like you know him well enough to have an accurate opinion as to whether he's a trustworthy or an untrustworthy person?
Mm-hmm.
What's your opinion?
I feel like he's a trustworthy person.
Do you,
Family man.
do you feel like you know him well enough to form a pretty accurate opinion as to whether he's a violent or a not violent person?
Yes.
Is he a violent or
He's not.
how is he with children?
He loves children. He's a good uncle too.
To your knowledge, are all of his family and friends here in Humphreys County?
Yes, sir.
Have you ever had an occasion to watch or to observe an argument between him and Caitlin Miller?
No.
You never saw them argue with each other?
I mean, like physical?
No, just argument.
Yeah.
Who would you say was the more angry person during that argument? Who lost their temper? Was it Ethan or was it Caitlin?
Yeah.
Was Ethan trying to diffuse the situation and calm her down?
Yeah.
Did you have an occasion to observe Mr. Beard's children that he has with Caitlin Miller after he was incarcerated?
A time or two. Yes, sir.
What was their condition?
And when they showed up to the my sister-in-law, I guess you would say, their diapers were saturated, and sorry, I'm like stuttering, I'm really nervous. And I guess they haven't had a bath in a few days, and I don't know, the little girl's hair was really tangled and knotted up. She actually had to have her hair cut because I don't.
How was Ethan in terms of taking care of him when he was out?
I was told that he was
I'm
always
gonna
the,
object to hearsay.
he was always the one that.
Hold on, there's an objection. When there's an objection, you need to stop talking.
Yes, sir.
The objection is to hearsay, Mr. Simpson.
I'll withdraw the question.
Sustain the objection.
That's all I have, Judge.
Well,
Ms. Carter,
Mhm.
you were testifying a minute ago about the condition of the children.
Yes.
Was that, what time frame are you referring to?
It was like right before, or no, right after he went to jail.
Now, he didn't work, did he?
He did off and on in their relationship.
But he wasn't working at the time of this incident, was he?
No, ma'am. He was, I guess you would call the babysitter.
But Miss Miller was working, wasn't she?
Correct.
Are you aware of the current pending charges against your brother?
Somewhat.
You aware that he's been charged with aggravated assault and domestic assault against Miss Miller?
Yes, ma'am.
You aware that he is charged with choking her, with threatening to kill her, things like that? Are you aware that he is charged with child abuse?
Yes, ma'am.
Are you aware that there were bruises on the children when they were found in his care?
I was told that. Yes.
I'm sorry. Say that again.
I was aware. I saw that. I mean,
You
I heard that. Yes.
You're aware of the charges is what I'm asking.
Yes,
specifically.
ma'am.
You're aware he's also charged with stealing thousands of dollars worth of water from the city of Waverly?
Yes. And she.
I didn't ask you about that. I just asked if he was aware of the charge.
Yes, ma'am.
But despite of all that, you think he's all right?
Yes.
He can come home and be all right?
I hope so.
All right. No further questions, Judge.
thank you. Any redirect?
Briefly, Judge. You're asking questions on cross-examination. I know you're nervous. You're almost done. You're asking questions on cross-examination about the charges that are pending against Mr. Beard.
Mhm.
Based on everything that you know about him and everything that you've seen, would you be shocked if he actually did what he's accused of? Would that be out of character for him
Yeah,
in terms of the aggravated assault and assault?
yeah.
Would that be well outside of the Ethan Beard that you know?
Hmm. Very much so.
And as far as him, these allegations, uncharged allegations regarding his children, would him leaving bruises on his children be well outside of his character as well?
Yeah.
In all the times that you saw him with the children, did you ever observe anything that would make you concerned about his ability to take care of them
No.
in terms of abusing?
No, she would yell at him to discipline the kids before he even had kids with her.
That's all I have.
Thank you, ma'am. You may sit down. Our next witness.
Yes, Judge. Next witness would be Marshall Beard.
Beer, come around here, please. Ask you to raise your right hand and be placed under oath.
You solemnly swear or affirm that the testimony I give in this case should be the truth, whole truth, and nothing but the truth, so help you God. You have a seat.
Could you do me and the court reporter a favor, and when you talk, could you get right about this close to the microphone? Like you're trying to eat it. Thank you. All right. Could you please state and spell your name for the record?
Marshall Allen Beard, Marshall, SHALL, Allen, ALLEN, Beard, BEARD.
What is your relationship with Ethan Beard?
His uncle.
Have you known him his entire life?
Yes, sir.
How would you say that you two are close with one another? Have you two worked together in the past?
Yes, sir.
Have you observed his interactions with Caitlin Miller during their relationship?
Yes.
Do you feel like you know him well enough to form an accurate opinion as to his character for trustworthiness?
Yes, sir.
Is he an honest or a dishonest person? What is that?
He always been honest to me.
Do you feel like you know him well enough to form an accurate opinion as to his character for being violent or not violent?
Not that I know of. He's never been violent.
Would you say that being violent would be out of character for him? Or would you know him well enough to say that?
I know well enough to say that he's not very person.
Is he an easygoing guy?
Yes.
Have you ever, during your observation of either him and Caitlin Miller, him and the children, was there ever anything that was concerning to you in terms of him being violent towards them?
No, they love that Jay.
To your knowledge, do all of his friends and family reside here in Humphreys County?
Yes.
Are you able and willing to help support him through these proceedings in terms of making sure he's got a place to stay and all that sort of stuff? That's all that I have.
Boss?
Yes, Mr. Beard,
Yes,
did you say he would be living with you?
I'm sorry.
He wouldn't be living with, can you say yes or no?
No.
He would not be living with you. Okay. Did you live with Mr. Beard and Miss Miller when they were together?
No, ma'am.
So you didn't observe their day-to-day interactions, did you?
No, they always came to my house, me and my brother's house.
I'm sorry, could you speak up a little bit louder?
Him and Caitlin has always came to mine and my brother's house.
Okay, so I'm just asking you, you didn't live with them, you didn't see how they acted from day to day?
No.
Okay, so you don't know everything that went on in that home, do you?
No, ma'am.
Okay. No further questions, Judge.
Anything further?
That's kind of based on process. Did you know Caitlin Miller outside of her relationship to Ethan Beard?
Her sister.
Do you feel like you know her very well? No. All right, well, that's all I have.
Thank you, sir. You may step down. All right, next witness.
I think that's all I have at this time, Judge.
Defense is rested their proof on the motion for bond reduction. So I may call your first witness if you have him.
Yes, Judge, I call Officer Corey Field.
Corey Fields.
You solemnly swear or affirm that the testimony I give in this case should be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, ma'am.
Could you state your full name for this court, please?
Corey Field,
Where are you employed?
Waverly Police Department.
Were you working for them back in December, January, or December of 24, January of 25,
Yes, ma'am.
during the time frame these things happened?
I was.
Can you tell the court how you initially made contact or became aware of these allegations against Mr. Beard?
I received a phone call from Captain Wilson. I believe it was Corey Burnett had reached out to him about the allegations. Ms. Caitlin Miller and I forget his name, Justin Chance Miller were at a house on Main Street, wanted to speak with an officer about it. The other two children that were involved said that Justin Miller said that he had found bruising on the children.
Objection to hearsay.
Objection is to hearsay, Joe.
Well, Judge, I would say it's not being offered for the truth of any matter asserted. It's to establish how the officer was made aware that something needed to be investigated, or he needed to speak with Mr. Beard or do some kind of
I
investigation.
think you can testify about the fact that he was investigating something without repeating the hearsay. So it's just a objection.
You were made aware of certain allegations
The
against
complaint
Mr.
was these allegations. Yes, ma'am. I should rephrase. So I spoke with them on scene and was made aware of these allegations. And was also made aware that the two youngest children were currently at home with Mr. Beard. And he was along with them. And then it was at that time that I spoke with Caitlin Miller, who broke down in front of me and was very frantic, I'd say. She was crying, she was shaking, she was seemed afraid. Given the allegations, she also has pictures at that time. I believe she had pictures at that time. She had pictures in her possession. I can't testify that I saw them at that time, but
Do you recall what the photos were, what they were?
significant bruising to her. Several pictures of significant bruising to her neck, her throat area, her arms. Given the allegations of abuse to her and her allegations of his abuse toward herself and all four children, and the fact that he was home alone with two of these children at that time, we went directly to the house to go ahead and take him into custody before taking out felony warrants for aggravated assault.
So you were going to take out a felony warrant against him?
Yes, ma'am.
So it wasn't just a warrant for domestic assault, it was a warrant for
It
felony.
was for a felony aggravated assault strangulation, based on her statements from an assault that occurred.
Okay. And do you recall how old the children were that were in the home?
I believe they were 4 and 7-ish. I'd have to refer to my report on that one. They were younger than 8.
Okay. If your report said they were 2 and 3 years old, would that be correct?
That's probably more accurate, yes, ma'am.
So who all was with you when you went out to this residence?
Officer Campbell, and I believe Miss Caitlin Miller's sister, Lauren Robertson.
I'm sorry, what's the name?
I wish I could tell you. I believe it's Robertson, something like that.
Okay, I just mean
I'm
as far as
sorry.
officers go.
Just McCampbell,
Okay.
Officer McCampbell and myself.
Okay. And is that residence here in Humphreys County, the city of
Yes, ma'am.
Waverly? Okay. When you got there, did you attempt to make contact with Mr. Beard?
We did. We knocked on the door multiple times. We announced ourselves. I heard what sounded like a young child yelling inside of the house. I went around to the side of the house, following where I was hearing the yelling coming from, and found a bedroom window that was wide open. I yelled through that open window to try to make some kind of contact. I never heard anything other than this one child yelling. I had every reason to believe that either he was in there with them, and if he wasn't in there with them, then now we have a child that's in there by themselves. So
Did you announce that you were police?
multiple times, yes, ma'am.
Okay. Did you attempt to make entry through the front door?
We did. Someone there had a key that I guess Ms. Miller had provided. So we were able to unlock the door rather than having to kick it in. But when we unlocked the door, I found that it was barricaded, closed. There was a railing from a baby crib that was wedged up underneath the, I believe it was wedged up underneath the doorknob. I had to force the door open to get into the home. We entered the home. I had my taser drawn at this point, which normally would have been a firearm, but given the fact that we knew there were children there, I didn't want to do that unless it's necessary. We went toward the direction of where the screaming had come from, and saw Mr. Beard at the end of the hallway in a bedroom, sitting on a bed with the two children next to him. I gave him verbal commands to show me his hands and come toward me, which he did not immediately do. He, I guess you could say, kind of ushered the kids. He had the kids get up, and then ultimately I guess you say he kind of put the kids between us, between myself and him. Ultimately, he did stand up though, and cooperated and walked to me, and he was taken into custody without incident.
But initially, he put the children between you and him.
He didn't physically grab them and put them there, but he kind of, as you would, usher to, direct them to stand up and walk down the hallway.
Regardless of how he did it, they were between you.
Yes, ma'am.
And you had your taser drawn.
Yes, ma'am.
And he was the only one in the house with the children.
Yes, ma'am.
And what did the children look like?
They were very dirty. The house was very cold due to it being January and the window being open. Hair was matted. There were bruises on them.
And check to relevance. I don't think this has anything to do with the charges, and I don't think that has anything to do with
Your Honor, his charge.
what's going to happen if I may finish my objection. With what's going to happen, where he to be released on.
Judge, it has everything to do with the charge. It's charged with 2 counts of being felony and child abuse.
The issue has been raised by the defense by putting on all of this proof of all of these multiple witnesses about his lack of potential for violence and abuse of the children. So clearly this would be evidence to contradict or impeach the testimony of those witnesses. Overrule the objection.
Thank you, Judge.
One of the bruises in particular that was of particular interest to me was on I forget which child. There was a bruise on one of these children on their upper arm that appeared to be a handprint. And given the fact that the information that I had going in was the fact that they had been alone with Mr. Beard for quite some time, as Ms. Miller was the only one working in the home, these bruises appeared to be pretty fresh. Looked like a handprint on them. There were bruises on the legs of these kids. They were wearing nothing but a diaper, which was very soiled and heavy. It was cold in the house. There was no clothes. When we looked for clean clothes to put on them, we could not find any.
Couldn't find any clean clothes with children?
Nor could we find any diapers.
Okay. And as you were going, you had to find Mr. Beard. He was in the back bedroom?
Yes, ma'am.
Okay. And did you initially know he was back there, or did you have to find him?
We didn't know where he was when we entered the house. When we came into the house, it's a ranch style home. When we came into the living room, there's a hallway, and we looked down the hallway and he was sitting in the room, on the bed in the back bedroom.
And in the process of that, did you have an opportunity to observe the general condition of the home too?
Yes, ma'am.
What was that like?
Very, I would say neglected, but more so. There were animal feces all over the home. Carpets were soiled with feces, urine, was trash piled up in the corners. Mouse feces on the countertops, cigarette ashes all over the place. In the bedroom that he was in, which appeared to be one of the children's rooms, he was sitting on a mattress with there was no sheets or anything. There was, I believe there was animal feces in that room. In the adjacent room that appeared to be his room, we later learned was his, there were cigarette burns all in the mattresses. There was a full coffee can full of cigarette butts and ashtrays sitting on the bed right next to a marijuana pipe and what appeared to be a rolling tray with marijuana residue on it. And it was a video game that was paused, which stood out to me because it seemed like, I'd have to speculate, but video game being paused, like it had just been turned off or just been stopped when we showed up.
Okay. So you took photos of the children and of the home, correct?
Yes, ma'am.
And you have provided to the state the photos of Miss Miller and her bruising that she had on her, correct?
Yes, ma'am.
So Mr. Beard was charged with child abuse or neglect under the child abuse and neglect statute, correct?
Yes, ma'am.
And at that time, he also had a felony warrant taken out against him for aggravated assault against Miss Miller, correct?
Correct. So we didn't, I secured the warrants after taking him into custody.
Yes,
Yes,
ma'am.
ma'am. Yes, ma'am. They were all taken out at the same time.
Okay. And Mr. Beard also, as far as his charges go, he received 11 counts of violation of bond conditions after he got to the jail, correct?
I believe that's correct. Yes, ma'am.
What would that have been for?
He contacted Miss Miller from the jail, and I listened to those phone calls. And in those phone calls, Miss Miller never stated a word. You could hear her trembling and crying, but she never said anything. He stated multiple times in these phone calls that he knew that he was not supposed to contact her, and that he knew that he was probably going to get in trouble for contacting her. And just to clarify too, I don't believe there were 11 phone calls that she answered. There was one call that she answered that I listened to, but I believe 11 attempts.
Oh, okay.
But yeah.
All right. And then, are you aware of another set of charges against Mr. Beard of theft and vandalism?
Yes, ma'am.
And can you tell the court what the basis of those are?
So a couple days after Mr. Beard was arrested, my understanding is that Ms. Miller went to the City of Waverly Water Department to have the utilities put into her name because with him being incarcerated, now she was trying to keep the lights on and such. And when she went to put the water into her name, because she had never dealt with it before, I guess it more or less flagged it in the system. My understanding is that the water had been cut off to the residents about 2 years prior, and some kind of issue with their systems. For some reason, the City of Waverly was not aware that the water service had, the house had been getting water again after it had been cut off. But when she went to apply to put the water into her name, and they looked at that account, they realized that this house has been receiving water for the past 2 years after it had been locked. So a utility worker went to the house, checked the meter, and found that the lock that they had put on the meter had been cut off and removed.
So a lock had been broken on the meter?
Yes, ma'am.
Okay. And that account was in the name of Mr. Beard?
Yes, ma'am.
Okay. And he had been effectively stealing water for about 2 years.
Yes, ma'am.
And based on that, did he get charged with felony theft and vandalism?
Yes, ma'am, he did.
And all these charges occurred about the same time, correct?
Yes, ma'am.
No further questions, Judge.
Sensing, we will cross-examine.
As an initial matter, you drafted a couple incident reports that detailed your investigation into this case. Is that correct?
Correct.
And is it fair to say that you put every major observation that you made during your investigation into those reports?
I believe I did.
And is it fair to say that you detailed every major action you took during the course of your investigation into those reports?
I believe that's fair to say, yes, sir.
It's fair to say you're trained that that's important to do, right?
Yes.
And is it fair to say that your memory was fresher then about everything than it is now?
Most definitely.
You also testified at the preliminary hearing in this case. Do you recall that?
Yes.
And again, it's fair to say that your memory was fresher then than it is now.
Yes.
So with that in mind, I just have some questions. Now, you testified that you had responded to a call concerning certain allegations. Is that correct?
Correct.
But those allegations weren't the abuse allegations against Ms. Miller.
Excuse me?
The initial allegations didn't have anything to do with Caitlin Miller being abused.
When I went to the address, I believe the only information I had at the time was that something about child abuse. These were not called directly to dispatch. Which this happens often in a small town. Someone will call the captain or the chief or the sheriff, or whoever, and we'll get relayed to that to investigate it. But I can't recall honestly as to our initial, if it was just the children or if it was children and Miss Miller. I don't believe it was Miss Miller.
Initially, that's something that came.
Yes.
And that's something that came out when you approached her to ask about what's going on.
Yes, sir.
And that call came in on January 12th of this year.
Correct.
And Miss Miller is not the one, as you said, you originally called it.
No, sir.
And the most recent alleged assault that she talked to you about occurred on December 2nd of 2024.
Yes, sir.
So that's over a month ago.
Yes, sir.
Was all of your interactions with all the witnesses at the scene, as well as Ms. Miller, was that captured on your body cam?
It was.
Is that body cam footage still available?
It is not.
Now, you testified on direct that you had received some photographs from Ms. Miller about her injuries. Is that right?
Yes, sir.
Okay. But this was afterward. This wasn't at the scene. She sent them to you later.
I believe it was either that night after he was taken into custody or the following day when she came in. So this was late at 10 o'clock or later that this happened. She came in the following day, I believe, gave a written statement as well. And I'd have to refer to my report, but those pictures were either given to me that night or the following day. I'm not sure which.
Okay. And it was 10 p.m. after you had arrested and booked in Mr. Beard?
Yes.
Would it be fair to say that you originally responded about 6:30?
That sounds about right. Yes.
And do you recall how she sent them to you? Did she email them to you or text them to you?
She had them on her phone, and they were time stamped over the course of several months, which is why she was able to give a detailed account of the dates that these allegations of abuse had occurred, which was documented in her written statement. She had her phone with her. I reviewed the photos on her phone for the purpose of viewing the timestamps on the photos to see when they were taken. And then they were airdropped, I believe, from her phone to my iPad that I do my reports and stuff on for work.
So she had an iPhone?
I believe she did. They were sent directly from her phone to my, they were either emailed or I think they were airdropped. I couldn't say for sure.
But your recollection was that they were airdropped?
I believe they were.
You didn't actually get a forensic copy of her phone, did you?
No, sir.
I believe after, so prior to you getting the pictures, and let me just back up really quick. The allegations prior to placing Mr. Butte under arrest, all of the allegations as far as Ms. Miller and the children that you shared together, that was, she just had alleged that he had been abusive towards her.
Correct. No, wait, hold on. What, can you, ask that again? I think I may have.
As far as the children that they shared with one another,
Right.
and those children were the ones who were present with Mr. Beard in the home when you placed him under arrest.
Right.
Prior to you placing him under arrest, the only allegations that Ms. Miller made were about him assaulting her.
No, that is not correct.
Oh. And you. And you have a transcript of the preliminary hearing. I believe your testimony starts on page 21. If you could turn to there, and then once you're satisfied that that's an accurate reflection of your testimony, I'd ask you to turn to page 33.
Okay.
All right, are you on page 33?
Yes.
You recall testifying at the preliminary hearing words that, quote, Ms. Miller didn't seem to be aware of the actual physical child abuse part of it, because she stated that she put herself between him and the children, so I guess she didn't feel that he was much of a danger to you.
So I guess to clarify that.
But you did say that.
Yes, I'm not disputing anything that's said in this. I believe I may have misspoke or stated that poorly. Ms. Miller did state, and I believe it is also in my narrative on the report that was done before this testimony. She did state that, like I said, she said that she had put herself between him and the children, that he had been abusive to her and the children, that this had been a situation that they were living in for some time. I believe what I meant by this, again, I'm trying to remember this. She didn't feel that he was an immediate threat to her or to the children at that time.
Okay, but that's
she
fair.
was the only one working.
All right.
She had no other
I
option.
mean, and she said that she didn't feel that they were an immediate threat to them at that time. Okay. You didn't charge him with child abuse based on anything that she had said about that, did you?
No. All right. My original intention was to refer all the child abuse stuff to CID because that was going to require forensic interviews and stuff like that, which is why I never spoke with the children. My original intention for going to that house was to arrest him for the aggravated assault on her.
Okay. And so, as far as you're aware, after you referred it to CID, those charges were never filed.
As far as I'm aware.
And the reason that you went to Mr. Beard's home without a warrant was based on exigent circumstances.
Yes, sir.
And when you arrived at Mr. Beard's home, you testified you initially knocked on the door and announced yourself, walked around. You said on direct that you heard a child yelling through an open window. Is that right?
Heard a child yelling from inside the home, yes.
But
I believe the window being open made it easier to hear, but. Yes.
But it's fair to say that the sound was just kind of kids being kids.
Yes,
There
no,
were
not
signs of
screaming. The
distress.
child was not screaming in pain or anything like that. I heard a child inside the home.
So no signs of distress.
Correct.
And in fact, after nobody had answered, let me back up. Was this arrest and your interactions with Mr. Beard in the home, was that originally recorded on your body cam?
Yes.
But that's also been destroyed?
I wouldn't say it's been
It's been
destroyed,
lost.
it was lost. Yes, sir.
I didn't mean to imply that was done.
I understand.
And after no one answered, is it fair to say that you had entertained options of either crawling through that window or kicking down the door?
I did, yes, sir.
But Ms. Miller's sister happened to be there. She had a key. And you used that to enter the residence.
Yes, sir.
So when you're talking about how it was barricaded, did you have to like bust it open? Did it make a lot of noise, or was it just kind of like there in front
I
of the
wouldn't
door?
say that it made a lot.
Move it out of the way.
I'm sorry, I didn't let you finish. We pushed it out of the way. I mean, I wouldn't say that it made a lot of noise. It didn't make the noise that it would have made it had we had to kick it in or something like that.
But it didn't take a lot to get it out, to maybe get it or whatever.
It took a shoulder.
It was at the height of your shoulder?
No, it took me forcing the door open with my shoulder to get past the barricade, the crib rail or whatever it was.
And again, you testified you knew that there were children inside.
Yes.
And you didn't have your guns drawn because of that.
I didn't have my gun drawn. McCampbell was behind me. I can't testify whether or not he did. I couldn't say. But no, I had my taser drawn.
At no point during your time inside the house did you point your taser at Mr. Beard or the children?
I believe so.
And you testified, you said he ushered both of the kids down the hallway towards you?
Like I say, I'm not sure the best way to describe it. He sort of motioned for the kids to get up, and they started walking toward us.
Where were the children relative to Mr. Beard and yourself when you initially saw him?
I believe they were on either side of him, sitting on the bed.
And the reason that you charged him with child endangerment was that he failed to answer the door, which necessitated you making entry with your taser drawn.
The reason that I charged him with child endangerment is I was there to serve a felony warrant for aggravated assault. And when we got there, he had barricaded himself inside the home with the children, which meant that we had to force entry into the home, which typically would be done with guns drawn, thereby putting these children at risk of severe bodily injury or death. And then when we got in there and found those children in the condition that they were in and fresh bruising on them, I felt it necessary to go ahead and charge him with the child abuse of that. For the totality of the circumstances of what we found when we went in there, the condition of the kids, the condition of the home, and the fact that he had barricaded himself inside of that home with those children.
Could you please, on that preliminary hearing transcript on pages 29 to 30 at the bottom, please let me know when the court asks you why did you charge him with child abuse and neglect, what specific, and then your response to that.
What are you asking?
You saw where you answered the court at the preliminary hearing, and you testified, you recall, that my basis for charging on that child endangerment, well, back up, because the TCA lists endangerment on the same statute, my basis for charging him on that child endangerment was because he barricaded himself inside of the house with the kids, and the only reason we didn't go in there with guns drawn in these circumstances was because I knew that there were children. Is that what you said?
I'm sure it is.
Could you show me where you said that you charged him with child abuse or neglect based on the state of the house?
I didn't charge him with child abuse and neglect based on the state of the house. Like I said, the condition of the children and the fact that they were barricaded in their bed. He would have been charged for neglect for the state of the house, but
could you show me where in there, or, and I'm happy to answer your incident report, where you stated that you charged him with child endangerment based upon the state of the children and not because he barricaded himself in the house? I guess I looked at your incident report and I looked at your preliminary hearing testimony, and I do not recall you ever stating until your testimony today that the basis for your charging him with child endangerment had anything to do with the state of the children or the state of the house.
I guess in my mind, the state of the children.
You referred that to CID, right?
I referred the cases of the other to follow up. Yes, I referred those to CID to follow up.
You never questioned the children about where those bruises came from?
I did not, no.
You never questioned any other witness who told you that they knew where those bruises came from?
I spoke with Justin Miller, his wife Christian, Caitlin Miller. No, I did not speak with anyone else, and I intentionally did not question the children because I'm not a forensic interviewer.
So you're making, okay. And did you have any reason to believe that anybody would have tipped Mr. Beard off that day, that the police were going to come arrest him for an assault that occurred more than a month prior?
Objection, speculation.
I'm asking him, did he receive any information that would lead to that conclusion?
Well, the question is, does he have any information? That's not speculation. That's the question of whether he did it or not.
I did not have any information from anyone that he may know we're coming.
You also, I believe, testified about an alleged marijuana pipe that was in a separate room from where he was with the children.
Yes.
To your knowledge, there was no suspected marijuana found. First of all.
Did not find any marijuana. We didn't search the house.
Okay. And to your knowledge, has that pipe ever been tested to determine whether there was any marijuana actually in it?
I'm sure it probably has not.
Now, concerning the water theft, you received some documentation from the city of Waverly that detailed the amounts. Is that right?
Correct.
I can show you that document.
Yep.
Is that what you received? Is that a fair and accurate depiction?
I'm sure it is.
I'd like to make that an exhibit.
What is it?
If you would pass that to Mark, I have a copy of that I'd like to ask you about. Well, actually. And I believe in speaking with the city, they informed you that the water had been going to the house after it was cut off since January of 2023.
I believe that's correct.
And I believe they also informed you that the lock that would have been cut off was about $20 to replace the valve.
Okay, right.
Would it help you if I showed you your incident report to refresh your memory?
That'd be fine. I'm not arguing with you if that's what they.
Well, I just want to make sure that I'm getting it right.
I'm sure that's probably correct. Yeah. Oh, I see why. I see where you're going now. If I may, I can explain this. I'm sure you're going with the discrepancy between the amount of the report here and the amount that's on that.
No. But is it fair to say, I could retrieve that document if you're satisfied? The lock was about $20.
Right.
And service, they had been receiving water at that address without paying for it since January of 2023.
That was just my understanding.
As far as the bond violations, I think you testified that only one of the phone calls was answered. To your knowledge.
I believe that's correct, yes. That's what it is.
And all of these calls took place within this few days after him being arrested.
I believe so. I'd have to refer to that.
But let me ask you this, to your knowledge, have the calls been ongoing over a long period of time, or were they confined to?
To my knowledge, they were not ongoing over a long period of time. They were confined to that.
And listening to that audio, did he make any threats to her?
I'm not sure where it's relevant, but no.
Did he tell her that she better drop this case or else?
No.
Did he say what he was going to do when he got out of jail to her?
Don't believe so.
Was his tone mainly remorseful over the wrongs that he perpetrated during their relationship?
Again, I'm not sure where it's relevant, but yes, sure.
If I could, I do have a video that I'd like to show you. Yes, and I can show you first. I just received this very recently.
You know what I mean? I don't know where Mr. Simpson is going with this, but I would remind the court this is a bond hearing, not a jury trial.
It is a bond hearing, not a jury trial, and much of the evidence that I've heard goes to issues that are not necessarily before the court on a bond motion. And this is a video. What is the video of?
It's a video showing Mr. Beard's arrest taken from his perspective.
Showing what?
It's a video showing Mr. Officer Field arresting Mr. Beard, shot from his perspective.
And what is the relevance of that on the bond issue?
Well, the strength of the state's case goes to a factor as far as bond, and furthermore, this was testified to on direct, and so I'm just merely clarifying things.
No. We'll take a short recess and then we'll see the lawyers back here soon.
All rise.
Oh, that's all right. They're being distracted. Mr. President?
Yes, Judge. Just wanted to show you a video. See if you could authenticate for me. No, obviously you didn't take it.
Are you going to play it on the big screen for everyone to see?
Well, I don't know if I know how to connect it. I was just going to show him, and if he can authenticate it, then I was going to introduce it as an exhibit.
I've seen it, Judge, sometimes. Just show me.
Yeah, I should.
George. Oh, missed it. George has caught the ball. Hey! Well done, George. Now you throw the ball to Pepper. There. Oh, there. Try again. Put her down from there. Pass was long. Let's put it in. And this one. George cannot show the ball. Somebody dig. Come on, George. Give it to me. My kids are here by themselves. I understand that. I'm not. Turn around, hands on your back. Yes, sir. Did you not hear us knocking on the door? I heard somebody knocking, but I thought it was mine. You didn't hear me yelling police department? No, sir, I did not. You know what we're here? I have no idea. Okay. We'll get to that. Hey, you let them know that they can come in here with for these kids now. Hey, Mom. Is that Mom? Who is she? They don't know her. She's at, she's there, Dad. No. So you taking my kids? I'm not.
So I know that you're not the one who took that video, but would you say that that fairly and accurately depicts you arresting Mr. Beard on the date that you were testifying to? Okay, so that's an objection. I would just introduce a USB stick with that.
I won't be considering it because I haven't watched it. But
Well, I was going to publish it next.
there you go.
How would you like me to publish it, I guess?
Well, it doesn't matter to me how you wish to publish it, but if you're showing him a video, and if I'm gonna have to consider it, I'll have to watch the same video. It would have been probably easier to put it up there, but it doesn't matter. Are you wanting me to watch it? Is that correct?
Yes, Judge, if you just wanna use my laptop, I figure that might be the easiest, unless there's like a HDMI I can plug into. Should be more prepared for that, but just kind of. Here you go, Judge.
George? Missed it. George has caught the ball. Well done, George. Now you throw the ball to Pepper. Milk. Milk. Try again. Throw it out. Milk. George cannot throw the ball past Money Pig. Come on, George. Give the ball to me. My kids are here by themselves. I'm doing it. Turn around, hands on your back. Yes, sir. Did you not hear us knocking on the door? Somebody knocked about it was mine. You didn't hear me yell at the police department? No, sir, no. You know what we're here? I have no idea. Okay. We'll get to that. Hey, you let them know that they can come and do this for these kids now? That's my mom. Their mom? You say the mom? Who is she? They don't know her. She's at her dad. No. So you take my kid? I'm not.
With that, Judge, that's all that I have of this witness.
You right?
Yes, Judge. Now, Mr. Field, you saw the video that you were just showing, correct?
Yes, ma'am.
And you've been testifying from your memory up to now, correct?
Yes, ma'am.
You were never able to review your body cam footage
No, ma'am.
due to it being lost?
Yes, ma'am.
And in that video, you can see one of the children in a playpen, correct?
Correct.
Having watched that, does that refresh your memory as to what,
It does.
can you tell the court specifically what you saw that day?
I would just say that it's walking down the hallway, obviously a very stressful situation. I distinctly remember seeing a child on each side of Mr. Beard. I distinctly remember Mr. Beard, when I told him to come to me, I said the word usher. I'm not sure what the best way is to describe it. The child that was next to him, I'm not sure if the child was on his lap or on the bed. I don't dispute the video, but
You do recall seeing a child being, well,
yes, ma'am.
between you and him?
Yes, ma'am.
At least one child?
Yes, ma'am.
Okay. And again, just for purposes of refreshing the court's memory, the door was barricaded?
Yes, ma'am, it was. And photos were taken of the crib that barricaded the door.
Okay. And is your testimony true and accurate to the best of your knowledge?
Yes, ma'am, it is.
And this happened back in January of this year, correct?
Yes, ma'am.
No further questions.
Recross?
Very brief moment, Judge, and just. You testified that you took a photograph of the baby gate that was in front of the front door, that was behind the front door?
Yes, sir.
That's all.
Nothing further, Judge.
Thank you. Officer, you may step down. State you may call your next witness.
Your Honor, state will call Caitlin Miller.
Caitlin Miller. Well, if you'll come out around here, please. I ask you to raise your right hand and face the clerk.
You solemnly swear or affirm that the testimony I give in this case shall be the truth, the whole truth, and nothing but the truth, so help you God. Yes. Thank you. Now state your name.
Ms. Miller, can you state your full name for me, please?
Caitlin Burnett Miller.
Scoot up to that microphone. Everybody has a hard time, but you have to basically directly speak into it for the pickup. Okay.
Ms. Miller, were you in a relationship with Mr. Ethan Beard?
Yes.
Okay. And did that end back in January of 2025?
Yes.
Okay. And
Speak up now.
Yeah, you're gonna have to really
This
get
lady
close.
here on this side of me has got to write down everything that you say. So when you talk softly, she can't hear you. So be sure to speak up.
just as loud as you can. You live in Humphreys County or in the city limits of Waverly with Mr. Beard, correct?
Yes.
Okay. And what was your address at that time?
106 Powell Avenue,
In Waverly?
Waverly.
Okay. And did you speak with Officer Field of the Waverly Police Department back in January 2025?
Yes.
Okay. And what did you tell him?
He came to my mother's home, which is where I was at the time, and told him what my 8-year-old son had told my ex-husband and the abuse that had been going on with us and the children.
Okay. Did you specifically tell him about several instances where you were assaulted by Mr. Beard?
Yes.
Okay. Can you tell the court about, whether or not it was physical abuse or what kind of abuse it was?
Physical and mental.
Okay. And how did he physically abuse you on the occasions that you told Officer Field about?
He tied a hoodie string around my throat and tried to strangle me. I had a bruise on my arm from where he punched me. I had an imprint of a water bottle on my side where he threw it at me.
What kind of water bottle?
Dasani.
Would it be a metal or plastic?
Plastic. He pushed me over on our 3-year-old daughter, trying to get a hold of my neck.
Did he grab you by the throat multiple times?
Yes.
And when he grabbed you by the throat, how did he grab you?
With both hands trying to strangle me.
Did it leave marks on your neck?
Yes.
Did you take photos of those?
Yes.
Did you provide those to law enforcement?
Yes.
Did he also threaten to kill you or harm you?
Yes.
What specific threat did he make?
That he would put me 6 foot under the ground and make sure that I didn't breathe again.
Did he also threaten to slit your throat?
Yes.
What did he say when he was saying that?
That he was going to, I don't want to cuss,
It's all right. Go ahead.
that he would slit my throat if I took his children away from him.
Did he ever hit you with his fist
Yes.
more than once?
Yes.
And can you tell the judge the approximate time frame that these incidents occurred?
No, October, November, December of 2024.
And you have photos of multiple injuries, correct?
Yes.
And you documented those and brought those to law enforcement?
Objection,
Yes.
stating,
Stay, don't leave the witness.
You took photos of the injuries?
objection.
Oh, let me rephrase it, Judge. Did you take photos of the injuries?
Yes.
Did you provide those to law enforcement?
Yes.
How did you provide those to law enforcement?
I believed they were time-stamped photos that were either airdropped or sent to him to his email.
Did you have any other photos that you provided to law enforcement?
I provided everything that I had that night.
Were you aware that Mr. Beard had broken the lock on the water meter, whatever it is that you're at the residence?
Was not.
You were not aware? You're aware that the water that you had was not being paid for?
No.
In fact, did you give Mr. Beard any money?
Yes.
What did you give him money for?
The water bill and multiple other things. I mean, he didn't work.
How long a period did he not work for?
The entire time we were together, 5 years.
And you worked,
Yes,
were you working pretty much the whole time?
yes,
So he was home alone with the children the majority of the time?
yes.
Are you afraid of Mr. Beard?
Yes,
Did Mr. Beard try to contact you once he was in jail?
yes.
Did he speak with you on the phone?
I never spoke to him on the phone.
But did you answer a phone call from him?
Yes,
Okay, and he spoke to
and he
you?
spoke, yes,
And did he try to call you multiple other times?
13 times.
And this was after he had been arrested and in jail, correct?
Yes.
No further questions, Judge.
Sensing, you may cross-examine.
Do you recall roughly when the last phone call was?
The last phone call that from
Yes,
jail,
that you received from him?
I believe it was January 17th. It was the night my dad died, so the 17th.
And, okay, so I kind of want to ask, there's some questions about the photographs you sent to Officer Field. You testified that you may have airdropped it to him, is that right?
Yes,
Okay, so you took those photographs with an iPhone, an Apple iPhone?
yes.
Talking about the water issue, you testified that you didn't know anything about the water issue. Is it fair to say that you had informed Officer Field on January 12th that Mr. Beard was the one giving you money for water bill?
I gave him money for the water.
Or sorry, that you gave Mr. Beard money for the water bill?
Yes,
And that was reported to Officer Field at the same time, like when you first spoke to him?
I believe so.
When did you go to change the water into your name?
I don't remember the exact date. 2 weeks, a week or 2 weeks. I don't remember the date.
After Mr. Beard was arrested?
Correct.
Now, Mr. Beard is charged with two counts of this assault, right? One on December 1st, one on December 2nd. Do you recall what happened on December 1st of 2024?
I don't remember the exact dates.
I'm asking you specifically about the time in which Mr. Beard was alleged to have threatened you.
Okay.
On December 1st. Do you recall that?
I don't remember specific dates to each threat, no.
The one where he said that he would slit your throat if you took the children away?
Okay, yes.
Do you recall what was the context in which that was said? Like what was going on? What happened before that?
Usually me complaining about him getting a job and helping with bills would start the argument.
Do you recall specifically if that's what that was that day?
I don't recall specifically, no.
Do you recall whether you took notes about it, or how did you recall that it had happened when you spoke to
I
Officer
have
Field?
photos that are time stamped, and I do have notes in my phone, but sitting here right now, I don't remember specific dates.
When he threatened you to slit your throat, I mean, did he have a knife?
No,
Do you recall making a written statement that gave sort of a timeline of all of the abuse to Officer Field?
yes,
And to the best of your knowledge, did that written statement contain everything that you recalled at the time?
yes,
So if that written statement on December the 1st just said the only thing that it included was the threat that he would slit your throat, but there wasn't any sort of physical abuse, would that be accurate?
no, there was physical abuse.
I mean, on that day.
I don't remember specific dates.
I'd like to show you a document just to refresh me.
Okay.
Was there any, to your recollection, did you allege that he physically assaulted you on December 1st, or was it just the threat?
No, put his hands around my throat.
On December 1st?
Yes.
Is that reflected on that written
multiple
statement?
occasions. He grabbed me in the living room and pushed me on top of our 3-year-old daughter.
Okay, if I know true. If I could show that to you again, does that say December 1st or December 2nd?
December 2nd.
So would it be fair to say that that was December 2nd?
Correct.
So what you put in that written statement about December 1st, was that accurate?
Yes.
And good. Was there anything on December 1st about him putting his hands on you?
Specifically on December 1st, correct? No.
But other than what's in that written statement about that specific date, your testimony is today that you don't have a clear recollection. What happened?
I do have a clear recollection. I just don't know specific dates.
Well, that's what I'm asking. You can't really differentiate what happened on this date versus that date.
Sure. Okay.
That's all, Judge.
Anything further from the state?
No.
Thank you, ma'am. You may step down. State may call your next witness.
State has no other witnesses, Judge.
State has rested their proof. Do you have any rebuttal proof, Mr. Sensing?
No, Judge.
All right, I'll hear you an argument.
I did a little reading during lunch. I think that at the outset, it's important to remember that what we have here before the court today are a set of allegations. A set of allegations that are unproven and that have not been subjected to a jury trial, in which Mr. Beard stands presumably innocent. And so this court's job, as I'm sure it well knows, is to determine what is the least onerous conditions that are necessary to make sure that Mr. Beard appears in court and to make sure that Mr. Beard isn't going to be a danger to the community upon release. And there are a number of factors that I think I'll get into, but which point towards either giving him a signature bond with a GPS monitor or giving him a bond of no more than $5,000 or $10,000 bail amount. So starting with the fact that it's undisputed that Mr. Beard has been a resident of this county for his entire life. He has no meaningful contacts outside of this county. He is not a flight risk. So in terms of making sure that he's going to appear in court and run away, I mean, there's no evidence that would support that at all. As he has no criminal history except a B misdemeanor driving on a suspended license. He has no record of any failure to appears. And certainly he doesn't have a criminal history that would suggest that he's at all a danger to the community at large. He is, even if he is convicted. Well, let's talk about the strength of the state's case, starting in 15063, water theft. If the court looks at the bill that I tendered as an exhibit, you'll note that the only water that was actually stolen, this is a theft of property case, it's like $500 or $600 worth of water. Now, maybe the state has a case about a misdemeanor theft, but in terms of this felony theft, where they're including late fees and broken lock fees, service fees and all of that, that's not what was stolen. Okay, so this is not a felony theft case. It is a misdemeanor theft case. And it is a misdemeanor theft case in which the vandalism charge was filed outside the statute of limitations. If Mr. Beard had been stealing water allegedly since January of 2023, the lock would have been cut then. This was not filed within a year. So the state's strength on the vandalism count is non-existent. Turning to 15064, in its amended response to my motion for a bill of particulars, the state has amended its indictment or superseded its indictment to charge Mr. Beard with child endangerment. It claims it's a B felony, but if the court looks at the statute, that is child endangerment by exposure to a non-Schedule 6 controlled substance. And there's absolutely no evidence at all to suggest that Mr. Beard is guilty of that. And even if Mr. Beard was guilty of the A misdemeanor child endangerment, which would have been the proper charge, there's no evidence that he placed his children in imminent risk of harm. There was never a gun pointed at them. There was never a taser pointed at them. There's no evidence on that video that he ushered them in front of him to try and barricade them between him and the police. And he's not charged with any of this 404B evidence about the house or the bruises or this and that. He's only charged with child endangerment. And if the court looks at the state's amended response to the bill of particulars, the allegation is that he put his children at risk if he failed to answer the door. Weak case. Possession of unlawful drug paraphernalia, well, there was no marijuana found, and there's been no testing to show that it had marijuana residue on it, so I would argue that that's also weak. 15065, the A misdemeanor domestic assault, aggravated assault, violation of no contact order, that sort of stuff that's going to have to go in front of the jury. Obviously, the allegation has been made over a month after the fact in the context of a different investigation entirely. But whether or not if that's sufficient proof beyond a reasonable doubt, she says there's photos of these injuries. They are not in evidence before this court. All we have is her allegation that it occurred, and she testified that she didn't have a clear memory about what happened. And then again, there's all this 404B propensity evidence that was put on that is not relevant to the crime for which he's charged. His bond is currently set at $75,000. And at the end of the day, I think the state's going to get, at best, some misdemeanor convictions and maybe a C felony aggravated assault. And if the court looks at TCA 4035-1026A, he is a presumptive candidate for probation. He has no criminal history. There have been no efforts to rehabilitate him that have failed. He will be guilty of a C felony, which makes him a presumptive probation candidate. So he's likely to get a probated sentence where he to be found guilty after trial. I don't mean to presume, but that's what the statute says. So in terms of the proof, strength of the state's proof, and the likely sentence that he would receive if convicted, I would say that those don't bear upon him being a flight risk either. People get probation for these sorts of things all the time. And again, I'm not trying to put words in the court's mouth, but we'll see what the proof comes out of trial and the sentencing. There's multiple members of the community who have vouched for him, multiple members of the community who gave testimony that are at stark contradiction to what the state's trying to paint here as far as Mr. Beard being this abusive person. So when considered in the context of, is he going to appear in court? Is he going to go out there and terrorize the community if he's released? And he's presumed innocent. All of these factors favor releasing him on either a signature bond with a GPS monitor, no contact order with Ms. Miller and the children. And I should say, the violation of the bond conditions, I think we didn't have the recording, but Officer Field himself testified that he got through to her once and he wanted to apologize. That's what he wanted to do. That's why he called her. He didn't call her to threaten her. He didn't call her to try and tamper with her testimony or anything like that. So if the state gets up here and says that he's a danger to her because he violated his bond restrictions, I think it should be said that the reason that he didn't care if he got into trouble, maybe he will, is because he felt like it was important to apologize. Is it wrong? It's illegal. But does that show that he's a danger to her? I don't think it does. And so what I would ask the court to do in consideration of Mr. Beard's fundamental right to be released on its minimum amount of bail conditions as is reasonably necessary to make sure he shows up to court, he doesn't reoffend. I would ask the court to, like I said, either give him a signature bond with conditions that we have a GPS monitor so that we can keep tabs on where he is, he's not going around here with the kids, or set bond at no more than $5,000. Thank you. I think I put $10,000 in my motions.
Chairman McLeod,
Yes, Judge.
Judge, first of all, state would disagree with defense counsel's summation of the strength of the state's cases here.
shocking.
Starting with the vandalism and theft case. Your Honor, it's the state's understanding that the statute of limitations activates, for lack of a better word, once the victim becomes aware of the crime. The city of Waverly was not aware that the law had been broken. Now, whether they should have been aware or not is another question, but they weren't. When they did become aware, they notified law enforcement immediately, and he was charged. The state also disagrees with defense counsel's assessment that it's only a misdemeanor theft as opposed to a felony theft. But again, the state does feel that is a matter to be addressed at trial and a jury question. As far as the aggravated assault, the state believes it does have a strong case. Your Honor, the state didn't introduce all the photos because again, this is a bond hearing, not a trial. But there's the victim testified, the officer testified separately, the victim was outside when the officer testified. Their testimony corroborated one another. Photos have been provided, defense has those photos. The state believes that the assault case is very strong, that there will be a conviction, and further, the state would argue that aggravated assault is in a category of crimes that is not listed as probatable if convicted in a jury trial. I understand the court would still do that, but it's not necessarily clear that that is a charge once convicted that one could be put on probation for. Moving to the child abuse statute, Your Honor, defense argues that 3915-401D1, which reads in full, any person, let me find it. Make sure I reference the right one. Any person who negligently by act or omission engages in conduct that places a child in imminent danger of death, bodily injury, or physical or mental impairment commits a Class A misdemeanor, except that if the abused child is 8 years of age or less, the penalty is a Class B felony. So Section 2 then goes on to say, for purposes of this subsection, a person engages in conduct that places a child in that situation if the child is exposed to a drug that's not Schedule 6. The state's reading of that statute is that that is simply one aspect of what the statute is intended to cover. It is not necessarily reserved exclusively for children exposed to drugs, but for any conduct that can put a child in that danger. That's why Mr. Beard was indicted under that statute, due to the state's belief that his actions would fall into that category. The state disagrees that that law would apply only to drug offenses. The violation of bond conditions. Mr. Stinson seems to think that, or his argument at least, is that the defendant's violating of his bond conditions can be excused if the purpose of the defendant's phone calls are to apologize to the victim. The state would argue that perhaps Mr. Beard was trying to influence or coerce the victim to drop her allegations, maybe accept his professions of being sorry and let him off the hook. So the state doesn't believe that his apologies are sincere. In fact, the state would argue that his conduct in repeatedly violating those bond conditions, while stating that he was aware that he knew he was doing so and would get in trouble, shows a complete disregard for the law and for orders of the court. And again, Your Honor, this is a bond hearing, it's not a trial, as you're aware. Mr. Sensing states in his motion that the state has submitted no evidence or articulable allegation that would, if true, make the defendant guilty of child abuse and neglect. And the state just simply disagrees with that. We believe that the evidence is overwhelming in this case, Your Honor. Yes, the pipe wasn't checked for marijuana residue, but the jury can determine whether or not they think it was being used for that, or he was just smoking tobacco out of it. Your Honor, the state does agree that under the bond statute, there are multiple requirements and factors that the judge would look at. And several of those do favor defendant as far as length of residence in community, members of the community to vouch for him, the fact that he has a very minimal prior criminal record, that he wasn't already on release when he committed the majority of these offenses or is presumed was charged with them, except for the violation of bond conditions. But, Your Honor, the state does feel that based on the testimony we've heard today, that the probability that he would be convicted of the majority of these offenses is a great probability, that he is a danger to the community. Based on the testimony, Your Honor also heard that there are other children in which he has not been charged that also have bruises and marks of abuse on them. As far as employment, we heard that he hasn't had a job for 5 years. That would also favor the state. But in summation, the state would say that the bond of $75,000 is more than appropriate. But if Your Honor does feel inclined to lower that at all, the state would ask that he be required to pay for a GPS monitoring device and also pay for the victim to have the notification as well. Thank you, Judge.
Respondents to,
Right.
first of all, got the jury instruction here. With respect to this B felony child endangerment, it's an act, it's an uncontroversial canon of statutory construction where the statute embraces a general, something general, and then something specific. Specific parts should be limited to that. This statute, 3915-401, already has a child endangerment. That's a general child endangerment. And that's in subsection C. It's class A. Then, in subsections D and E, it has special drug exposure child endangerment. And the fact that it has one for meth and for fentanyl underscores the fact that those two subsections are limited to drug exposure by a methamphetamine or some other non-Schedule 6 controlled substance, which includes marijuana, Schedule 6, or again in subsection D2, fentanyl, which increases the penalty to an E felony rather than an A misdemeanor. So, respectfully, I think that Tennessee Sentencing Commission, when they wrote the jury instructions, agreed with my interpretation, and I can't see any appellate court not agreeing with my instructions. So it's an A misdemeanor child endangerment. Again, if it's child endangerment at all, there's no imminent threat that I heard today. And the next thing that I want to address is the state's talking an awful lot like he's already been convicted and we're at a sentencing hearing. We're not here to punish Mr. Beard for what he may have done. We're here to assess is he a danger. And again, these bond violations, there's nothing that the state's speculating, well, maybe he was trying, even though he didn't say anything that would suggest that he was trying to influence her testimony, maybe because he felt bad and apologized, he had this plan to try and get her to change her testimony, even though that wasn't expressed. So does that make him a danger to her while he stands presumed?
Can I respond to it? I'm
You
sorry.
may, the public defender will have the final say no matter what, but I'll give you another opportunity if you want to respond.
Well, Judge, I was just wanting to say that the state's argument is based on Mr. Sensing's argument that we don't have, the likelihood of conviction is low. We know we're not at a sentencing hearing. But I did want to briefly point out that looking at the statute for child abuse and neglect, 3915-401A refers to a person who knowingly and other than by accidental means inflicts injury on a child. Subsection B refers to a person who knowingly abuses or neglects a child to adversely affect their welfare. And subsection D, which is the one that he's charged under, refers to negligent acts, including, it says by act or omission. So the state would argue that different things are being met by each statute. And subsection D is referring to negligent behavior. It doesn't have to be intentional. That's all the state wanted to say.
Stacy, you have the final say.
Other than the fact that if the legislature were to criminalize negligence in such a way that you might potentially, possibly put a child in imminent danger would be horrifying. But also, it stands to reason that if negligence is the standard, then it's exposure to a controlled substance. And again, she overlooks, she goes through subsection A and subsection B, skips to D, because C is where you have child endangerment by a parent who has a parent or custodian who actually has the duty to care for a child, puts them in imminent danger of death or serious bodily injury. And I suppose I'll end with this from Professor Lawrence Tribe, and it's a quote that I think bears sayings from the law review article that I heard at our conference, and it's this. Quote, the system will appear to be it's about bail arguments. The system will appear to be malfunctioning only when it releases persons who prove worse risks than anticipated. The pretrial misconduct of these persons will seem to validate and will indeed augment the fear and insecurity that the system is calculated to appease. But when the system detains persons who could safely have been released, its errors will be invisible. And so this court errs too harshly on Mr. Beard. If he could have been released with the least onerous terms possible to ensure that a man in a free country who stands presumed innocent until proven guilty doesn't stay incarcerated for over a year for crimes for which he has not been convicted. I would just ask the court to account for that too, because I know all too often all the weight's on danger of the community. Somebody gets cut loose and they do something bad, it makes us all look bad. But I think that we should pay attention to the other side too, because again, it's part of what makes this country great.
Well, what makes this country great is the fact that we do have a system of laws and rules, and we have a constitution that guarantees people to have certain rights that are protected by law. One of those rights is the fact that a person is presumed to be innocent. So we have that argument to make that this public defender has certainly made many times here today, is the fact that Mr. Beard has not been yet convicted of anything. So the court has to consider the evidence that is presented at this hearing. And the evidence that has been presented at this hearing is consisting of multiple people who have testified about Mr. Beard and his conduct and his character and so forth, and the type of person he is and how he's nonviolent and so forth and so on. Contrary to that, and how he's reliable and all of those things are presented as a means of trying to satisfy some of the factors that are set forth in the bail statute. And I'll touch on those in a minute. The state has presented evidence through the testimony of the officer and the victim of the alleged victim in one of the cases that tends to contravene or contradict the testimony of all of those character witnesses of Mr. Beard. So the court is cognizant of the fact that this is not a trial on the merits and beyond a reasonable doubt, and that is not the standard that the court applies in a bond reduction hearing. So we can argue all day long that a person is presumed to be innocent, and certainly under that, everyone would be released without any kind of restriction on their liberty because they're presumed to be innocent. But our law provides that there are certain factors that must be met, and that a recognizance bond or a bond of appearance can be required of anyone who is charged with a crime. And while Mr. Beard is not yet convicted of anything, one of those charges is a very serious charge of aggravated assault by strangulation. Now, the court is aware of the fact that while he has not been convicted, and Mr. Sensing argues that these are allegations that are unproven. There is truth to that, but for the purposes of this bond hearing, this court finds that the credible testimony of both the officer and the victim in the case established that there is a high probability that the defendant is in fact guilty of these offenses, based on the uncontradicted testimony of the victim alone, that he did in fact attempt to choke her and did in fact threaten her and so forth. Yes, that is not proof beyond a reasonable doubt, but that's not the standard for a bond hearing. The bond hearing is for me to determine what factors there are present and what factors would be required. The fact that he violated his bond conditions by contacting the victim, attempting to contact her by the evidence 13 times, and only connecting with her, answering it one time, and then, as Mr. Sensing points out, he may have done so to apologize. Anyone who's dealt with domestic violence cases on a regular basis, and I've done it for longer than I would care to remember, there is a pattern. And we often wonder, why do victims of domestic abuse, especially women, continue to stay in relationships where they're abused? One of the patterns that we see consistently is that that person says, well, he's promised to do better. There was a promise that I'm sorry, I apologize, I'll promise to do better. And so they stay with them because they have children or other factors. So the fact that Mr. Beard contacted the victim in violation of the bond condition, in this court's opinion, just to apologize is nothing more than consistent with what abusers often do in cases involving a victim. They try to apologize to try to lessen the punishment that might be inflicted upon them. So those are the findings that I make specifically, factually, in this particular case, applying my findings to the factors that are set forth in 4011-118 of the Tennessee Code, which have to do with the amount of the bond and the factors to be considered. The court looks at the defendant's length of residence in the community. He's a lifelong resident of the community, and that is a factor that favors him. 2, the defendant's employment status and history and financial condition, provided that his ability to pay shall not be considered. He is not employed, and therefore that's a factor that does not favor him. 3, his family's ties and relationships. He obviously has family ties and relationships with friends and people who have come to court to testify for him. That's a factor that does favor him, although clearly their opinion of his personality and so forth runs counter to what some of the other proof was in this case. That's not always unusual for someone to not, family members to not always see the other side of the family member's character. The dependent's reputation, character, and mental condition. Again, the evidence of character here has been introduced, is the family members and friends of the defendant who vouch for his reliability and trustworthiness and so forth, and the fact that he's not a violent person. His prior criminal record, he has no prior criminal record. So that would be another factor that would favor him. Nature of the offense and apparent probability of conviction, likely sentence. Again, the argument is made that he's not yet been convicted, but the proof that's been presented at this hearing presents a strong case that indicates that if these photographs are introduced at trial, if in fact he has done these things, that there's a, and the evidence before me at this hearing is that there's a strong case that he has likely committed the assault against his girlfriend and Ms. Miller, and that the fact of the matter is that it's a strong likelihood that he may be convicted of that case. He is charged in that particular case with domestic assault and aggravated assault in violation of a protective order. No question he violated a protective order. Even Mr. Sensing admits that, but minimizes it by saying he was just doing it. He was violating that to apologize. And in the testimony before me was he knew he was doing something that he wasn't supposed to do, but he did it anyway. I think that there's, at least in many of those cases, a strong probability of conviction. As to the child abuse, neglect, or endangerment, I am of the opinion that those cases may not be as strong because of the nature of the statute. That will be something that'll have to be dealt with, but I do not place great significance on the strength of those cases. The theft of property and vandalism obviously is a circumstantial case. I have the opinion that based on the testimony that's been offered, that the circumstantial evidence is strong that Mr. Beard was the one who cut the block off, and that was the reason why the theft of water. We can minimize the fact that it may have been a smaller amount of water as what was said, but I think the statute would allow the consideration of the actual amount of water along with any other damage to the property. So I think that there are two of the three indictments. There's, in this court's opinion, a fairly strong probability of conviction. The sentence to be imposed on an aggravated assault case by strangulation depends on the judge, the sentencing judge, and all of the factors. But it's not an automatic, just because he has no prior record, that he would be entitled to probation. It would be considered, but it is not an automatic thing. As a result of that, the court who hears the case and has to do the sentencing would have to consider all of the sentencing considerations set forth in the Tennessee Code, one of which is the fact that a sentence should be imposed that does not diminish the severity of the offense. And that would be something that clearly the sentencing judge would have to consider. The identity of responsible members of the community will vouch for his reliability. Obviously, those people have appeared today and testified. Any other factors indicating the defendant's ties to the community are bearing on the risk of the defendant's willful failure to appear, including but not limited to whether he is lawfully present in the state. I am of the opinion that one factor that this court places great significance upon is the fact that he violated the bond conditions in the past by contacting Ms. Miller, and that indicated that he did so knowing that he could likely get into trouble and knowing that he was violating the law when he did so, but he did it intentionally. And again, there are ways you can explain it. One of those options is that he was genuinely contrite and wanted to apologize. Another possible explanation is that he, like many other abusers, was attempting to minimize the punishment to himself and to try to sway the victim in the case against testifying against him by apologizing and trying to say that I won't do it again. So, applying all of those factors and considering the severity of this court and the amount of the current bond, the court finds that the bond should be set at $50,000. He will be required, if he makes that bond, to have a GPS monitoring device installed at his expense. He would also be required to pay the expense to make sure that Mrs. Miller would have the ability to monitor that, whatever the law provides regarding that. In addition to that, he is to have no contact with Tiffany Miller whatsoever, by directly, indirectly, by text message, by mail. He'll have no contact with her, period. And that is a court order that will apply whether he makes bond or not. In addition to that, he will only have contact with the minor children that were in his care at the time that he was arrested, pursuant to an order of the Domestic Relations Court or the Juvenile Court. That is, my opinion, an order that is required for the safety of Ms. Miller, as well as, and I'd take that action and set the amount, and in both the recognition of the severity of the injuries to her and the seriousness of the charge. I have a case many years ago where a young man who was in his 20s thought to present it was a Stewart County case. He thought to try to take one of his friends who was out of line for a ride and straighten him out. He got behind him in the back seat of the car and tied a shoelace around his neck, and thought that was a good prank to try to teach him a lesson. As a result of that, when his friend started turning blue, he kicked him out of the car and panicked and drove off. That man died, and that person is now serving a life in prison as a result of having been charged with first-degree murder. So strangulation of anyone, even in an argument or whatever, is completely unacceptable and is a very serious criminal offense. And for that reason, this court places great importance on the facts that were presented to me, as well as his violation of the prior bond restriction. And I make those findings on the record so that if there is any issue raised about why I have set the bond and made those conditions, it is very clear. That's the judgment of the court.
Hey, thanks for watching. Please do let us know in the comments what you thought of this video. If you'd like to support what we do here, the best way to do it is to pick up some of our merch. You can find it at courtroomfiles.com.